What is copying? From the perspective of copyright law, copying means taking the whole of a copyright-protected work or a substantial part of it without permission from the rights holder unless it is being used within the rules of a copyright exception. Taking the whole of a copyright-protected work and copying it is copyright infringement. This means reproducing it and includes sharing it or selling it. Taking a substantial part of a copyright-protected work is also copyright infringement. This means taking the original and protectable elements of a copyright work. It relates to the quality of what is taken, not quantity. The original and protectable aspects of a copyright work are the parts where the creator has expressed their own individual creativity and made their own personal choices. Once a claim proves reasonable access and substantial similarity, it turns to the alleged infringer to try to demonstrate that they created their work independently, without the influence of the existing work. This is where keeping a record of your creative process can come in handy. What is not copying? Not copying, then, according to copyright laws, is creating an original work by using your own skill, labour and judgment, or creating your own intellectual creation by making free and personal choices. It is not copyright infringement to draw inspiration from others' work. Moreover, it is not copying to take unprotectable elements from existing works. For example, the 12-bar blues, one of the most prominent chord progressions in popular music, has a distinctive form in phrase, chord structure, and duration. This common chord progression would not be protectable by copyright. There are no free creative choices in using it as it appears. It is not copyright infringement to copy an idea, because copyright does not protect ideas, only the original expression of an idea. The idea of a romantic song or a song to celebrate birthdays is freely available, and you can create your own expression of these ideas without infringing any copyright. Unconscious copying. Unconscious copying, from a psychology perspective, is where a person's implicit memory influences their behaviour even though the individual is not aware of its influence. In other words, it is the influence of previous experience on task performance without conscious referral to stored information, essentially learning without awareness. From a copyright law perspective, primary infringement does not require knowledge of the infringement. While it does need to be shown that the alleged infringer heard the song, it does not need to be shown that they copied on purpose or even that they knew that they were copying. For this type of infringement, the evidence provided to convince a court of infringement is likely to be much more significant. In the UK, the argument for unconscious copying was presented in the case about the song Little Spanish Town, discussed in Chapter 12, but the court made no comment. In the US, unconscious copying was argued in the case involving George Harrison from the Beatles. A claim was brought against Harrison that his song, My Sweet Lord, copied the Chiffons' 1962 hit song He's So Fine. The songs had similarities that were considered to be unique, and Harrison acknowledged that he had heard He's So Fine before writing My Sweet Lord, although Harrison argued that he had created it independently. The court decided that the two songs were musically identical except for one phrase, and that while Harrison did not deliberately copy, he was still liable for copyright infringement. The court said that while Harrison was playing around with multiple possibilities for combinations of notes, a particular combination pleased him because he unconsciously already knew it had worked in a song which his conscious mind did not remember at that moment. Therefore, it was an infringement of copyright, even though unconsciously accomplished. How many notes can be taken from someone's song? Applying the rule of substantial taking, there is no number of notes that can be used from someone else's song which we can say would or would not be copyright infringement. This is a misguided question. It should not be asking how many, but rather which ones can be used. Again, this is about taking a substantial or insubstantial amount, the quality of what is taken, not the quantity. It is decided on a case-by-case basis, looking at the importance of the parts taken and their degree of originality.